The story of housing discrimination in America is long and tangled, its roots winding deep into the nation's past, back to slavery, through the collapse of Reconstruction, and into the century that followed. Even after the Civil War ended the legal status of slavery in 1865, the promise of freedom for millions of African Americans was quickly undermined by a new system of laws and customs designed to enforce racial separation in every aspect of life. Nowhere was this more evident or more consequential than in the search for a place to call home. After emancipation, the era known as Jim Crow took hold in the South. Segregation became the law, dictating where Black Americans could live, work, and gather. Housing was no exception. In the aftermath of the Civil War, Black families seeking to own land or build communities faced legal barriers and violence. The struggle for fair housing began here, in the shadow of a society determined to keep white and Black Americans apart. As the 20th century dawned, the industrialization of northern cities brought new opportunities, and millions of African Americans left the South in what became known as the Great Migration. From 1910 to 1970, Black families moved northward in search of better jobs and relief from the most brutal forms of Southern racism. But while the North offered escape from Jim Crow, it did not promise equality. Instead, segregation took on new forms. Cities responded to the influx with policies designed to contain and separate. In Baltimore, for example, city officials enacted race-based zoning ordinances, explicitly designating entire neighborhoods for white or Black residents. The Supreme Court intervened in 1917, ruling in Buchanan v. Worley that municipal governments could not legally enforce racial zoning. Yet this victory for civil rights was far from the end of the story. Rather than abandon segregation, policymakers and private actors turned to different tools, less overt but just as powerful. One of the most significant of these tools was the racially restrictive covenant. In the early decades of the 20th century, developers, builders, and white homeowners began to include clauses in property deeds that explicitly barred African Americans and, in many cases, other minorities from purchasing or even occupying homes in certain neighborhoods. The practice gained legal backing in 1926 when the Supreme Court upheld such covenants in Corrigan v. Buckley. Real estate professionals and homeowners associations promoted these restrictions, embedding them into the fabric of American cities and suburbs. These covenants were not merely symbolic. They exerted real force, shaping where Black families could live and blocking access to the new suburban development springing up around the edges of cities. By the 1930s and 1940s, these covenants had become so widespread that large swaths of urban America were closed off to all but white residents. Meanwhile, another, more insidious form of discrimination was gaining ground: redlining. The Great Depression of the 1930s devastated the housing market. In response, the federal government stepped in, creating agencies like the Homeowners Loan Corporation and, in 1934, the Federal Housing Administration. These agencies were charged with stabilizing the housing sector and making it possible for more Americans to own their homes. But the promise of federal support came with a catch, one that would shape the trajectory of American cities for generations. Federal housing policy, as it emerged during the New Deal, did not simply reflect private prejudices, it codified them into official practice. The Federal Housing Administration, for instance, was instrumental in institutionalizing redlining, a practice that systematically denied mortgage insurance and loans to entire neighborhoods, almost always those with significant Black populations. Maps were drawn, color-coded to indicate risk. Neighborhoods marked in red were considered too hazardous for investment, not because of the condition of the buildings, but because of the race or ethnicity of the people living there. The Federal Housing Administration refused to insure mortgages in these redlined areas, effectively locking Black families out of the primary means of building wealth in 20th century America: homeownership. At the same time, the agency subsidized builders who agreed not to sell homes to African Americans, further cementing the color line in the suburbs. Federal Housing Administration policies favored loans for new suburban construction, which was largely off-limits to Black buyers, while urban neighborhoods with Black residents were left to deteriorate, denied both public and private investment. This was not a matter of individual prejudice alone. The federal government, in concert with the real estate industry and local officials, made exclusion a matter of policy. Public housing agencies also played a role, encouraging the development of racially segregated communities and reinforcing the divide between white suburbs and Black urban neighborhoods. Racially restrictive covenants and redlining became core tenets of the housing market, ensuring that communities of color, especially African Americans, were systematically barred from the economic opportunities that homeownership could provide. The effects of these policies were profound and lasting. Black families remained trapped in overcrowded, underfunded urban neighborhoods, often forced into public housing projects as private options were closed to them. These projects, rather than serving as stepping stones to upward mobility, became symbols of segregation and neglect. Meanwhile, generations of white families built wealth and stability in the suburbs, their access to good schools, safe streets, and healthy environments subsidized by the federal government. The injustice did not stop with the denial of mortgages. The post-World War II era saw the introduction of the Government Issue Bill, a program meant to reward veterans with access to home loans, education, and jobs. But once again, Black Americans found themselves excluded. Discriminatory practices in lending and real estate blocked African American veterans from taking advantage of these benefits, further widening the gap in homeownership and generational wealth. Urban renewal projects launched in the 1950s and 1960s promised to revitalize decaying cities. In practice, these efforts often resulted in the destruction of Black homes and businesses, displacing entire communities and deepening the cycle of poverty and exclusion. As highways cut through urban neighborhoods and downtowns were rebuilt, those who had been denied the chance to move to the suburbs found themselves pushed out of their homes with few options for relocation. The federal government was not blind to the consequences of its policies. Over time, a series of Supreme Court rulings chipped away at the legal basis for housing discrimination. In 1948, the court held in Shelley v. Kramer that racially restrictive covenants could not be enforced by the courts, though the covenants themselves remained on the books, shaping the choices of buyers and sellers for decades to come. Still, the machinery of segregation ground on, upheld by unwritten codes, discriminatory lending practices, and the inertia of tradition. By the 1960s, the cumulative effects of a century of exclusion and discrimination had become impossible to ignore. Activists, civil rights leaders, and ordinary citizens demanded change. Black leaders such as Robert Church Sr., Dorothy Height, and Whitney M. Young Jr. played pivotal roles in advocating for housing justice, shining a light on the abuses embedded in the nation's housing system and pushing for legislative reform. The struggle was arduous. Even as some forms of discrimination were challenged in the courts, new tactics emerged. Exclusionary zoning, ostensibly neutral regulations about lot sizes, building types, or minimum home values, became a favorite tool for keeping Black families out of white neighborhoods. These laws, while not explicitly mentioning race, achieved the same effect as earlier, more blatant forms of discrimination. Despite legal victories and mounting public pressure, the federal government did not move decisively to outlaw housing discrimination until the passage of the Civil Rights Act of 1968. Known as the Fair Housing Act, this landmark law made it illegal to refuse to sell, rent to, or negotiate with any person because of race, color, religion, or national origin. The act was a direct response to the long history of exclusion and injustice, an attempt to break down the barriers that had defined the American landscape for so long. Yet, even as the ink dried on the new law, the legacy of redlining and restrictive covenants remained. The patterns of segregation they had created did not dissolve overnight. Neighborhoods shaped by decades of official discrimination continued to experience disparities in wealth, health, and opportunity. The impact of redlining, for example, extended beyond economics. Formerly redlined communities often faced greater exposure to environmental hazards and poorer health outcomes, a legacy of policies that had prioritized white neighborhoods for investment and protection. Over the decades, evidence suggests that the structures set in place during the early and mid-20th century have proven remarkably durable. Redlining, first institutionalized by federal agencies between 1935 and 1940, created generational injustices that are still felt today. Racially restrictive covenants, though no longer legally enforceable after 1948, continued to influence housing patterns until at least the passage of the Fair Housing Act. Throughout, the partnership between government and private industry ensured that discrimination was not simply a matter of individual bias, but a system built into the policies that shaped where Americans could live, work, and raise their families. The seeds of change, however, were sown in resistance. Black families and civil rights leaders fought back, challenging unjust laws in the courts, organizing for fair housing, and insisting on recognition of their rights as citizens. Their efforts laid the groundwork for a new era, one in which the promise of equal housing opportunity would be enshrined in law, even if the path to its realization remained fraught with obstacles. In the end, the story of housing discrimination in America is not just a tale of injustice. It is also a testament to the power of ordinary people to demand change. The Fair Housing Act stands as a milestone in this struggle, the product of decades of advocacy and sacrifice. Yet the work it began is unfinished, its legacy visible in the neighborhoods and cities that still bear the marks of a divided past. The seeds of change were planted by those who refused to accept exclusion as a fact of life, and their struggle continues to shape the landscape of America today. By 1968, the United States stood at a crossroads. The tumult and hope of the civil rights movement had stirred the nation, but the realities of housing remained stubbornly unequal. Across cities, black families faced a daunting landscape of segregation, with stark numbers to prove it. Levels of black residential segregation were extreme, with the Black-White Dissimilarity Index hovering around 78 and the Black Isolation Index at 66. For those fighting for civil rights, these statistics were not just numbers, they were a daily reality, a vivid illustration of what it meant to live in a society divided not only by custom and prejudice, but by the literal walls and invisible boundaries of neighborhoods. Civil rights activists hoped that a new law could begin to dismantle these barriers and foster true desegregation. The Fair Housing Act, passed in April 1968, became the third major civil rights law of the decade. It followed the Civil Rights Act of 1964 and the Voting Rights Act of 1965, each addressing a different aspect of the American promise. While those laws targeted public accommodations in the ballot box, the Fair Housing Act sought to reach into the very heart of American life, the home. This was not a sudden awakening. The decades leading up to the act saw mounting pressure, legal battles, and a growing awareness of the profound inequalities embedded in the nation's housing market. In 1961, the Civil Rights Commission documented widespread housing discrimination. Their findings confirmed what black families and activists already knew. The deck was stacked, sometimes quietly, sometimes brazenly, against those seeking a decent place to live. The Commission's report painted a sobering picture. Discrimination was not confined to isolated incidents, but was woven into the fabric of everyday life. President John F. Kennedy responded the next year with Executive Order 11,063, the first major federal initiative aimed at applying civil rights protections to housing. This executive order prohibited discrimination in federally assisted housing, a significant, if limited, step toward fairness. It was a recognition at the highest level of government that housing discrimination was not just a private matter, it was a national issue demanding public action. But the road to comprehensive legislation was anything but smooth. Legal victories, though important, often proved to be only partial remedies. The Supreme Court had weighed in with landmark decisions, Shelley v. Kramer in 1948, and later, Jones v. Mayer Company in 1968, ruling that the law could not enforce private agreements to exclude people based on race, and affirming that black citizens had the right to contract for housing. Yet these rulings, however significant, did not erase entrenched patterns of segregation or undo decades of discrimination. Race-based housing patterns persisted, and the machinery of exclusion continued to operate in subtler ways. Advocacy organizations, including the National Association for the Advancement of Colored People and the National Committee Against Discrimination in Housing, took up the banner for fair housing. Their members lobbied relentlessly, pressing Congress to enact meaningful legislation. Demonstrations, letter-writing campaigns, and public hearings all became part of the effort as activists worked to keep the issue in the national spotlight. By the mid-1960s, it was clear to many that the problem could not be solved piecemeal. Only a broad national commitment could begin to move the needle. The civil rights movement's impact on housing was profound. Dr. Martin Luther King Jr. saw the struggle for decent housing as inseparable from the broader fight against segregation and injustice. In 1966, King and his family moved into a rundown apartment on Chicago's West Side, shining a harsh light on the realities of housing inequality in the North. He marched, spoke, and organized, making the case that where people lived shaped every aspect of their lives, from the schools their children could attend, to the jobs they could hope to find, to the safety and dignity of their daily existence. King's presence in Chicago was a turning point, forcing the nation to confront the ways that racism and poverty were intertwined in its cities. In early 1968, both Congress and the Supreme Court took unprecedented steps to combat housing discrimination, but the legislative process remained fraught with resistance. The National Association of Realtors, a powerful voice in the housing industry, initially opposed the Fair Housing Act, reflecting a broader current of skepticism, even hostility, among some segments of the public and within Congress itself. Many argued that such legislation would intrude upon property rights or disrupt established neighborhoods. Debates raged over the scope and enforcement of the law. Some critics warned that without strong mechanisms in place, any fair housing statute would lack the teeth needed to make a real difference. Yet the tide was beginning to turn. The Kerner Commission, established after the urban unrest of the mid-1960s, issued a chilling warning. America was moving toward two societies, separate and unequal. Their report underscored the link between racial segregation, economic opportunity, and social unrest. It was a sobering call to action that resonated with those who saw housing as the linchpin of the American dream and as a central battleground in the fight for equality. Events soon forced the issue. On April 4, 1968, Dr. Martin Luther King Jr. was assassinated in Memphis, Tennessee. The shock of his death reverberated across the nation, sparking grief, anger, and a wave of unrest in more than 100 cities. Suddenly, the urgency of the moment overwhelmed the inertia that had stalled fair housing legislation for years. President Lyndon Johnson, who had already shepherded two major civil rights bills through Congress, made a direct appeal for action, framing the Fair Housing Act as a tribute to King's legacy. For Johnson, its passage became a personal mission. He would later describe it as one of the proudest achievements of his presidency. The debates that followed were intense. The Fair Housing Act faced significant opposition, with critics raising concerns about its potential impact on property rights, local control, and enforcement. The law's mechanisms for enforcement were a particular point of contention. Some lawmakers and civil rights advocates worried that without stronger provisions, especially regarding lending discrimination, discriminatory practices would simply adapt, surviving in more covert forms. Others argued that the law went too far or not far enough, but the national mood had shifted. The riots and unrest following King's assassination had laid bare the costs of delay and inaction. The need for change had become undeniable. On April 11, 1968, just 7 days after Dr. King's death, President Johnson signed the Fair Housing Act into law. The timing was not accidental. The act was both a response to the grief and anger sweeping the country and a conscious effort to honor King's vision of a more just and inclusive America. The law, formally Title VIII of the Civil Rights Act of 1968, prohibited discrimination in the sale, rental, and financing of housing based on race, color, religion, or national origin. Its preamble spoke directly to the lessons of the preceding years, emphasizing the urgent need to decrease segregation and improve the conditions of neighborhoods across the country. Yet the passage of the Fair Housing Act was hardly the end of the story. The ink was barely dry before questions arose about how effectively it would be enforced. Critics noted that while the law marked a historic milestone, it left significant gaps, particularly in the area of lending, where discriminatory practices remained difficult to root out. Indeed, discrimination persisted in more subtle forms, as practices evolved to evade the new legal standards. The National Association of Realtors, for example, initially resisted the law's requirements, reflecting the broader resistance among some in the real estate industry. Over time, however, organizations like the NAR shifted their stance, coming to support the principles of fair housing and working, sometimes unevenly, to implement the law's requirements. The Fair Housing Act did not emerge in a vacuum. It was the product of years, indeed, decades of struggle, advocacy, legal battles, and shifting public consciousness. It was shaped by the courage of activists who marched, organized, and refused to accept the status quo, by the careful, sometimes painstaking work of lawyers and legislators who crafted its provisions, and by the seismic events of the 1960s, which forced the nation to confront the gap between its ideals and its realities. As the 1970s dawned, the Fair Housing Act stood as a testament to what could be achieved through persistent advocacy, legal ingenuity, and, sometimes, the galvanizing force of tragedy. It did not, and could not, erase the legacy of segregation overnight. But it marked a turning point, a moment when the nation committed itself, in law if not always in practice, to the principle that access to housing should not be determined by the color of one's skin, the faith one professed, or the place of one's birth. Looking back, it is clear that the passage of the Fair Housing Act was not inevitable. It was the result of relentless effort, shifting public sentiment, judicial milestones, and the catalytic impact of Dr. King's assassination. The Act's preamble, calling for an end to segregation and the improvement of neighborhoods, captured the aspirations of the civil rights movement and the hard lessons of the years that led up to it. While its enforcement would prove challenging, and while discrimination would persist in new guises, the Fair Housing Act remains a singular achievement born of struggle, loss, and the unyielding demand for justice. In the spring of 1968, as the ink dried on the Fair Housing Act, a new chapter in the American struggle for equality began. The law, co-sponsored by Senators Ed Brooke, the first black senator elected by popular vote, and Walter Mondale, was monumental in its ambition to outlaw discrimination in nearly all forms of housing across the United States. But what did this sweeping promise mean in practical terms, and how would it reshape the daily lives of those long denied fair access to homes and neighborhoods? At its heart, The Fair Housing Act aimed to ban the exclusion, limitation, or mistreatment of individuals in the housing market based on race, color, religion, or national origin. Later amendments would expand its reach to protect against discrimination based on sex, disability, and familial status. The principle was straightforward, but the mechanisms were complex, reflecting both the intricacies of the American housing system and the persistence of prejudices woven into its fabric. The law's protections were intentionally broad. It covered private and public housing, as well as housing supported by federal funds. Whether someone sought to buy a home, rent an apartment, apply for a mortgage, or purchase insurance, the Act declared that their race, color, national origin, religion, sex, disability, or familial status could not lawfully be used as grounds for denial or unfavorable treatment. The law targeted not only landlords and real estate companies but also municipalities, banks, and insurance firms. It recognized that discrimination was rarely the work of a single bad actor. It was systemic, embedded in the policies and practices of powerful institutions. The Act prohibited a wide range of discriminatory behaviors. It barred outright refusals to sell or rent to protected classes, but also addressed more subtle forms, offering different terms or conditions, misrepresenting the availability of units, or steering buyers and renters toward or away from certain neighborhoods. Even advertisements that indicated a preference or limitation based on a protected characteristic were banned. Importantly, it also shielded those who asserted their fair housing rights from retaliation, a measure that would prove necessary, as complaints of retaliation under the Act would only increase over time. Enforcing such a comprehensive mandate was a daunting task. The Department of Housing and Urban Development (HUD) was given primary responsibility for administering and enforcing the law. Individuals who believed they had experienced discrimination could file complaints with HUD, which would then investigate and, if warranted, pursue remedies. The Department of Justice (DOJ) was authorized to step in when there was evidence of a pattern or practice of discrimination, a recognition that some violations were not isolated incidents but part of broader schemes. The DOJ could bring lawsuits in federal court seeking to end discriminatory practices and, where appropriate, obtain damages for victims. Yet, from the outset, challenges became apparent. While overt, blatant acts of discrimination, such as explicit refusals to rent to families of color, became less common, more covert practices persisted. Scholars and policy analysts noted that weak enforcement and the continued influence of local control over housing policy limited the Act's effectiveness. Local governments, real estate boards, and financial institutions found ways to circumvent the law or slow its application, sometimes by creating bureaucratic obstacles, sometimes by simply turning a blind eye. The courts also played a pivotal role in shaping the reach and meaning of fair housing protections. In Jones v. Mayer Company, decided in the same year as the Act's passage, the Supreme Court affirmed the constitutionality of the Civil Rights Act of 1866, an earlier law that had granted Black Americans the right to buy, sell, and own property. The Jones decision reinforced the principle that all citizens must enjoy equal rights in the housing market, lending weight to the Fair Housing Act and clarifying that federal protections extended beyond mere words on paper. Still, the machinery of enforcement moved slowly. For many years, HUD's ability to investigate complaints, mediate disputes, and pursue legal action was hampered by limited resources and, at times, lackluster political will. The process often relied on individuals bringing forward complaints and being able to prove, often against well-resourced adversaries, that they had been treated unfairly. The burden of proof rested heavily on those who had been wronged, and retaliation, whether subtle or overt, remained a risk. Over the years, retaliation complaints under the Act would rise, a testament both to the persistence of discrimination and the courage of those willing to assert their rights. Recognizing these limitations, Congress revisited the law in the years that followed. The Fair Housing Amendments Act of 1988 marked a significant turning point, strengthening enforcement mechanisms and expanding the Act's protections. New provisions empowered HUD to initiate investigations and administrative proceedings rather than relying solely on the federal courts. The amendments also explicitly included protections for people with disabilities and for families with children groups who had long faced exclusion or disadvantage in the housing market. These changes were not merely technical. They signaled a renewed commitment to realizing the Act's original promise. Yet, as enforcement tools improved, new challenges emerged. Patterns of discrimination became more subtle, often taking the form of disparate impact policies or practices that, while seemingly neutral, had disproportionately adverse effects on protected groups. For example, a landlord's blanket policy against renting to anyone with a criminal record or a bank's mortgage lending criteria could result in racial or familial exclusion without ever mentioning race or family status. The question of how to address such indirect discrimination became a focal point of legal and regulatory debate. The disparate impact rule under the Fair Housing Act became a flashpoint, with shifting interpretations and ongoing litigation shaping the boundaries of what constituted unlawful discrimination. Courts and regulatory agencies wrestled with how to balance the need for robust protections with concerns about overreach or unintended consequences. At times, federal guidance and proposed rule changes signaled a more aggressive approach to enforcement. At other times, they reflected a desire to narrow the law's reach, emphasizing the need for clear evidence of discriminatory intent. The Department of Justice, for its part, has taken an increasingly assertive stance, particularly in matters of fair lending. Major legal cases have clarified the obligations of banks and mortgage lenders, holding them accountable for practices that exclude or disadvantage protected groups. The Department of Justice's involvement has been crucial in cases where patterns of discrimination extend beyond individual transactions, reflecting a recognition that systemic problems require systemic solutions. Despite these advances, the story of the Fair Housing Act is not one of unbroken progress. Weak enforcement, persistent local resistance, and the adaptability of discriminatory practices have all limited the law's effectiveness. Housing discrimination has not disappeared. In many cases, it has simply evolved. While overt, whites-only signs are now relics of the past, new forms of exclusion through zoning laws, lending policies, or subtle steering continue to shape where people can live, the schools their children attend, and the opportunities available to them. The enduring significance of the Fair Housing Act lies not just in its legal prohibitions, but in its affirmation of a core American ideal, that the right to a home should not be determined by race, color, religion, national origin, sex, disability, or familial status. Its passage was a watershed moment, achieved through the courage and persistence of countless advocates, lawmakers, and ordinary citizens. Yet, its promise remains, in many respects, a work in progress. Today, the Act stands as both a shield and a challenge. It provides a basis for individuals to seek justice when faced with discrimination, and it imposes obligations on those who build, finance, sell, and rent homes. Its legacy is visible in the gradual, sometimes halting movement toward more inclusive communities. But its limitations serve as a reminder that laws alone cannot erase the patterns of exclusion and inequality that have shaped American life for generations. As federal guidance and proposed regulatory changes continue to evolve, the meaning and reach of the Fair Housing Act remain subjects of debate and contestation. The rise in retaliation complaints, the continuing legal battles over disparate impact, and the persistent gaps in access to safe, affordable housing all testify to the unfinished nature of this work. The Act's legacy is not merely a matter of history, it is a living, ongoing struggle carried forward by those who believe still in the power of law to bend the arc of the moral universe toward justice. The Fair Housing Act did not, by itself, dismantle the deep structures of segregation and inequality, but it marked a decisive shift, establishing a federal commitment to the principle that where one lives should not be determined by prejudice or exclusion. Its provisions, enforcement mechanisms, and amendments tell a story of both the possibilities and the limits of legislative action. They remind us that the struggle for fair housing, like the broader pursuit of justice in America, is neither simple nor complete, but it endures, shaped by the courage and resilience of those who refuse to accept less.